Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today.
On today's episode of the podcast, we have the Queen and Jobidon, which is one of those seminal criminal law cases you kind of have to learn in 1L. And Carly, what do you remember about Jobidon?
So I remember really liking Jobidon because it's sort of, so it's a fight is what I remember. A fight happened and very unfortunately someone dies as a result of the fight. And it sort of gets into, well, can you really consent to this type of behavior? Like, can you consent to something like that? Can you consent to be hit by another person voluntarily? And I remember it was really neat just sort of getting into the nitty gritty of what consent means in this type of a context, and then how in certain situations we sort of completely suspend all of that, right? Like UFC is allowed and you are consenting to be hit. And
Yes.
So I always found, like the sport aspect very interesting, how, we made up this law and it's, we go through the whole explanation and then it's kind of like, well, but that doesn't really exist when you're talking about sports. So take it with a grain of salt in the sports world because it's a whole different ball game. So I remember that's what I liked the most about it, but I do remember liking the decision.
I remember liking it for the same reason, because obviously when you're in 1L, you don't necessarily read the whole case. And so when I was reading this case, Justice Gonthier, he actually, when he goes through it, he actually goes through like a long history of common law definitions of what consent is, dating back to, I think, as early as like the 1200s, if I remember right.
Yeah.
It's very old.
Yeah.
And so it's so cool to see how that definition of consent has advanced through the common law. And like there's some strong public policy arguments for not being able to consent to bodily harm, because I think, as the justice rightly points out, you don't want people to be fighting all the time in the streets and
Yes.
no punitive consequences flowing from it, because you would have a state of effectively chaos.
Yes.
Which is a fair
Yes.
point. But the
Agree.
flip side of that is violence in sports, right? Like we allow UFC and boxing, but fighting even in hockey. So
Yep. Yeah, and it's, the idea that, because a lot of the times when you're having conversations about the law being paternalistic, that can make people feel away for very sometimes legitimate and sometimes not so legitimate reasons, depending on what they're talking about, in my opinion. But this is an example where Gonthier is essentially like, look, sometimes the law is going to be paternalistic. This situation, it's being paternalistic here, and we're okay with that because we don't want people to be able to consent to just beat the crap out of each other all the time in the street for no reason. It's a very public policy-focused decision. It is, this happens a lot with the SEC, how they kind of you lose the facts of what happened because you're making sort of like a broader, wide-reaching public policy argument. Like, this is very sad. Like, someone died. It was not good. It's a very sad situation. But it's kind of like the facts just sort of get lost because you're sort of talking on the very big, very far away scale now about, well, what can you consent to in society, capital S? And it's, it happens with every SEC decision, really. But it's always weird. And I remember thinking that there was such a disconnect with the court in terms of what had actually happened and sort of the broad overreaching point that they were trying to make. And I don't think it was intentional. I think it's just what happens when things get to the court.
yeah, and especially on such like a philosophical question of like consent in terms of bodily harm, because obviously like consent has different meanings in different contexts and exists on a spectrum. And so in this case, we're talking about effectively fist fights for the most part.
Yeah.
Like, obviously there are other forms of like consent and fighting. Like, I know the justice gets in and discusses like you can never consent to a fight with weapons. Like, that's just not something we do as a society anymore. Dueling's a bygone era. We don't do that. But like fist fights will happen now and probably will forever happen.
Yes.
But as like a society, we don't value violence. And so you're right. Like, maybe in this case, they had to take a paternalistic view because this type of conduct writ large, just not what we value in this country.
Yes.
I don't know.
Yeah, they're big questions, and like there's no easy answers to this stuff. And I think I think I liked this decision because I felt like the court was trying to navigate something very complicated, and they did it in a way that, they made the best sense of it that they could given the information they had, and I think they did a pretty admirable job. Like this is not an easy thing to talk about.
Yeah, it's definitely not. So for all the legal history buffs, anyone interested in criminal law, this is definitely the case for you, and I hope you enjoy it. The Queen and Jobidon. On appeal from the Court of Appeal of Ontario. Writing for the majority, Justice Gauthier. At issue in the present appeal is the role of consent in the criminal offense of assault. More particularly, the issue is whether the absence of consent is an essential element of this offense when it relates to a fistfight where bodily harm is intentionally caused. Part 1. Statement of Facts. The appellant, Jules Jobidon, was charged with manslaughter for the unlawful act of killing Rodney Haggart through the offense of assault, alternatively through an act of criminal negligence. The incident leading to the charge was a fistfight between the two men in a parking lot outside a hotel near Sudbury, Ontario, on September 19, 1986. At the date of the killing, Rodney Haggart was 25 years old. He had consumed some beer. His blood alcohol level, measured a few hours after the incident, was 160 milligrams of alcohol per 100 milliliters of blood, but the trial judge found that Haggart appeared perfectly fine and perfectly normal. Jobidon, a young, fit, and powerful man, had also been drinking beer prior to the fight, but in the opinion of the trial judge, was not inebriated. The two men initiated their aggression in the bar of the hotel. With his brother and a few friends, Haggart was celebrating his impending marriage. He approached Jobidon, who was also in the hotel with friends, and started a fight with him. Haggart was larger than the appellant and had previous training as a boxer. In this first encounter, Haggart was prevailing when the owner of the hotel separated the combatants and told Jobidon and his brother to leave the hotel. Jobidon and Haggart exchanged angry words in the lobby, and the trial judge found that the two men agreed the fight was not over. Jobidon and his brother waited outside in the parking lot. When the Haggart party exited the hotel, the respective older brothers began fighting at the far end of the lot. Jobidon and Haggart argued. A crowd of people, many of whom had come outside to see the fight, gathered around them. While Haggart and Jobidon stood facing each other, Jobidon struck Haggart with his fist, hitting him with great force on the head and face. Haggart was knocked backward onto the hood of a car. The trial judge determined that Haggart was rendered unconscious by this initial punch and that he appeared to be out cold. He was not moving and offered no resistance to the appellant. Immediately after throwing that first punch, Jobidon continued forward. In a brief flurry lasting no more than a few seconds, he struck the unconscious victim a further 4 to 6 times on the head. The trial judge found that there was no interval between Haggart's fall and the continuing punch. The punches were part of one singular continuing transaction, one fluid event, punctuated by specific blows. The judge noted that the most reliable witness testified that it all happened so quickly he thought Haggart would bounce off the hood and resume the fight. Instead, Haggart rolled off the hood and lay limp. He was taken to the hospital in a coma, where he died of severe contusions to the head. Medical evidence showed that he had sustained extensive bruising and abrasions to the head and neck. It was determined that the cause of death was one or more punches he had received at the hand of the appellant in the parking lot. The trial judge found that Jobidon did not intend to kill Haggart, nor did he intend to cause the deceased serious bodily harm. However, the possibility of injury more serious than a bruise or bloody nose, such as a broken nose, was contemplated. Jobidon intentionally hit Haggart as hard as he could, but believed he was fighting fair. He did not depart intentionally from the kind of fight that Haggart had consented to. Jobidon believed that Haggart had consented to a fair fight, the objective of which was to hit the other man as hard as physically possible until that person gave up or retreated. The trial judge also found that, although mistaken and not supported by objective facts, Jobidon honestly believed that after Haggart had been struck onto the hood of the car, he was merely stunned, but still capable of fighting back and still trying to fight. Jobidon was tried before a judge of the Supreme Court of Ontario and was found not guilty of manslaughter. The judge held that Haggart's consent negated assault and held further that Jobidon had not been criminally negligent. The respondent appealed the judge's holding of assault to the Ontario Court of Appeal, which allowed the appeal, set aside the acquittal, and substituted a guilty verdict on the charge of manslaughter. Judgment in the courts below, Supreme Court of Ontario. The trial judge noted that the charge of manslaughter was based off the offense of assault under Section 265, formerly known as Section 244 of the Criminal Code, and that the Crown was required to prove each of the elements of assault to establish the offense of manslaughter. The judge characterized the legal issue before him as whether the consent of the deceased to a fair fistfight provides a defense for the accused. He noted that in England, consent does not provide a defense to a charge of assault. Yet, after reviewing the case law, referring to both English and Canadian authorities, he concluded that he was bound by the decisions of the Court of Appeal of Ontario in the Queen and Dix 1972, which held that the defense of consent applies to fistfights. Thus, he defined the only material issue before him to be whether the accused went beyond the bounds of the consent. Here, given his finding that the appellant had neither intentionally nor factually exceeded the scope of the deceased's consent, in part because the shouts from the crowd that it was a fair fight bolstered the evidence of the accused, he held that there had been no assault. Therefore, the appellant was not guilty of manslaughter. Ontario Court of Appeal. In a unanimous decision, 5 judges of the Ontario Court of Appeal overturned the trial judge's determination, substituting a verdict of guilty on the charge of manslaughter. The court disagreed with the trial judge's interpretation of the role of consent in the offense of assault. It concluded that, primarily for reasons of public policy, there are limitations on the extent of harmful conduct which one may validly consent and thereby bar conviction for assault. The Court of Appeal held that the applicable limitations on consent are those described in the decision of the English Court of Appeal, Criminal Division, in Attorney General's Reference No. 6 of 1980. The court read Attorney General's Reference as standing for the proposition that, quote, the concept of consent is limited and extends only to the applications of force where bodily harm is neither caused nor intended, end quote. Adoption of that approach entailed that, except for minor struggles, most fights will be unlawful regardless of consent. The Court of Appeal cited the following passage from page 1059 of Attorney General's Reference. It is not in the public interest that people should try to cause or should cause each other actual bodily harm for no good reason. Minor struggles are another matter. So in our judgment, it is immaterial whether the act occurs in private or in public. It is an assault if actual bodily harm is intended and or caused. This means that most fights will be unlawful regardless of consent. It also explicitly concluded that in the Queen and Dix, Supra, which had accepted that absence of consent was a material element of the offense to be proved by the Crown, was wrongly decided. Since the trial judge found that Jobidon had intended to cause bodily harm, in fact cause death, the Court of Appeal held that the Crown was not obliged to prove absence of consent. Therefore, since an unlawful act of assault had been committed and had resulted in death, the elements of manslaughter had been made out, and the Crown's appeal of the acquittal was allowed. Issues on appeal. There is one principal issue raised in the appeal, and one ancillary issue. The principal issue is whether absence of consent is a material element which must be proved by the Crown in all cases of assault, or whether there are common law limitations which restrict or negate the legal effectiveness of consent in certain types of cases. A secondary issue is whether Jobidon could be convicted of manslaughter on a basis other than that of an unlawful act of assault. Resolving the main issue calls for close scrutiny of the relevant statutory provisions in the pertinent case law. Before moving to that analysis, it is helpful to outline the major arguments made by the parties in this court. Appellant's arguments. The appellant argued that the Ontario Court of Appeal erred in its interpretation of Section 265 of the Criminal Code. Rather than apply the common law understanding of the role of consent, which sometimes limits its effectiveness as a bar to assault, the court should have accorded full effect to Haggart's consent as apparently required by Section 2651A of the Code. Section 2651A states that an assault occurs when, quote, without the consent of another person, he applies force intentionally to that other person, directly or indirectly, end quote. Section 2652 provides that, quote, "This section applies to all forms of assault, including sexual assault with a weapon, threats to a third party, or causing bodily harm and aggravated sexual assault," end quote. In the appellant's opinion, the trial judge's finding of consent meant that all the elements of the offense of assault had not been proved. The appellant should therefore have been acquitted on that basis, since the legislator intended that consent should be serving as a bar to conviction. According to the appellant, the legislature could have specified that in certain situations, or in respect of certain forms of conduct, absence of consent would not be an operative element in the offense. It had done so with other offenses. Parliament has provided that no person is entitled to consent to have the death inflicted upon him, Section 14. It restricted the concept in Section 150.1 and 159 of the Code by denying defenses to sexual offenses based on a child's consent. It also did this in Section 286 by negating the validity of young persons' consent to abduction. But with assault provisions in Section 265, it chose not to insert policy-based limitations on the role of consent. Moreover, in Section 265 sub 3, Parliament expressed specifically the circumstances in which consent would be vitiated on the grounds of involuntariness, but the circumstances described in that subsection do not include policy limitation applied to fistfights by the English Court of Appeal in the Attorney General's reference. The appellant further observed that, in England, the crime of assault is not defined in a criminal code but in the common law, to which common law limitations and exceptions more naturally apply. In Canada, we have a code of general principles by which, it is presumed, ambiguity is to be construed in the favor of the liberty of the subject. Finally, the appellant argued that the Court of Appeal did not appropriately characterize the Canadian common law. In its opinion, the Canadian jurisprudence shows that one can effectively consent to the application of force in a fist fight, even if bodily harm was intended and caused. Respondents' arguments. In step with the Court of Appeal, the Crown argued that the overwhelming weight of common law authority supports the position that one cannot validly consent to intentionally caused bodily harm in all circumstances, and that the law prohibits consent to street brawls or fist fights. It is not in the public interest that people should engage in these sorts of activities, so, on public policy grounds, the word consent in Section 265 of the Code should be read in the light of the common law, which limits its applicability as a defense to assault. The Crown also noted that fist fighting is without social value and has been outlawed in other common law jurisdictions. The respondent further submitted that Parliament did not intend to oust the common law limitations on consent. If Parliament had so intended, it would have made that intention far clearer. There exists an established interpretive principle that the legislator does not intend to make substantial changes in the existing law beyond that which is expressly stated or follows by necessary implication from the statute's language. Thus, since the statute says nothing about common law limitations being erased, one should presume they were left intact. The respondent argued that in the alternative, that if this court were to overturn the Court of Appeal's approach to consent, the appeal should nevertheless be dismissed because Jobidon caused the death of Hagar through the alternative unlawful act of causing a disturbance by fighting. Part 2. Analysis. 1. The evolution of the offense of assault in Canadian criminal law. To appreciate fully the issue of consent in this appeal, it is helpful to understand the historical evolution of the offense of assault, and to set the current statutory provisions against that background while attending closely to the interrelation of the criminal code and the common law. The following analysis is divided into two parts. The first examines the relevant provisions of the code, describes their origins, and makes a general argument about the nature of the common law's influence on them. The second sets out the specifics that the common law influence as it applies to the particular situation in this appeal. The offense of assault originally came to post-Confederation Canada as a crime of common law. Although the New Dominion in 1869 enacted a statute which simply adopts the English Offences Against the Person Act, nevertheless, the basic offense of assault was defined at common law. As criminal law historian Sir James Fitzjames Stephen once wrote, quote, "The law which deals with offences against the person assumes in the reader a previous knowledge of the doctrines of the common law relating to the employment of force against the person of another, and of the common law definitions of certain crimes to which the Act punishes but does not define." End quote. The Law Reform Commission of Canada described the relationship this way. Our law derives from earlier English law. That law in turn was built on two foundation stones: the common law crimes of assault and battery. In consequence, our present law is likewise built on these foundations, although both crimes are lumped together under the same name, assault. As a constituent element of numerous crimes, a common law assault was any act in which one personally intentionally causes another to apprehend immediate and unlawful violence. The traditional common law definition always assumed that absence of consent was a required element of the offense. As a general rule, an essential feature of assault is that it takes place against the victim's will. Thus, in most circumstances, it provided a valid defense to an accused. This makes sense when one acknowledges that the genuine consent of a complainant has traditionally been a defense to almost all forms of criminal responsibility. Canada did not adopt its first criminal code until 1893. So the English law was the primary foundation of Canadian criminal law. As Canadian courts gradually added to the English jurisprudence, our criminal common law increasingly became a blend of English and Canadian authorities. For decades, though, the definition of assault in Canadian criminal law remained virtually identical to the English common law version. That essential identity was not disturbed when Canada proclaimed its criminal code on July 1, 1893, since Canada's codification was very moderate, merely, quote, expressing the common law in neat statutory language to be interpreted by common law judges, end quote. Assault was given its first statutory definition in the Criminal Code, 1892, Statute of Canada, 1892, Chapter 29, in Section 258, which defined it this way. An assault is the act of intentionally applying force to the person of another, directly or indirectly, or attempting or threatening, by any act or gesture, to apply force to the person of another, if the person making the threat has, or causes the other to believe upon reasonable grounds, that he has present ability to effect purpose, and in either case without the consent of the other or with such consent if it is obtained by fraud. This definition reappeared unchanged in Section 290 of the 1927 revision and in Section 230 of the Code of the 1953-54 version. That definition was renumbered in Section 244 in the General Statutory Revision of 1970, and, following a supplemental change in 1976, was expressed as follows. A person commits an assault when a. without the consent of another person or with consent, where it is obtained by fraud, he applies force intentionally to the person of the other, directly or indirectly. B. He attempts or threatens, by an act or gesture, to apply force to the person of the other, if he has or causes the other to believe upon reasonable grounds that he has present ability to effect his purpose. Or C. While openly wearing or carrying a weapon or an imitation thereof, he accosts or impedes another person and begs. On January 4th, 1983, Bill C-127 was enacted. It amended Section 244 in significant ways. The first change was to serialize certain factors which would vitiate consent on the basis of a coerced or ill-informed will, thereby making consent legally ineffectual. See Section 244, Sub 3. As explained below in greater detail, these factors were not new, for they had already been a part of the law previous to the proclamation of the Code in 1982. Any novelty of Section 244 Sub 3 lay in its more explicit and general expressions in the Code. A second change was the addition of Section 244 Sub 4. It simply codified the traditional common law view that an honest belief by the accused that the complainant had consented to an application of force was a good defense to assault. Finally, Section 244 Sub 2 clarified that Sections 244 Sub 1, 244 Sub 3, and 244 Sub 4 were to apply to all forms of assault. The number of the assault provision was changed to Section 265 in the revision of the Criminal Code in 1985. The section now reads, a person commits an assault when a. Without the consent of another person, he applies force intentionally to the other person, directly or indirectly. Sub 2. This section applies to all forms of assault, including sexual assault with a weapon, threats to a third party, or causing bodily harm and aggravated sexual assault. Sub 3. For the purpose of this section, no consent is obtained where the complainant submits or does not resist by reason of Sub A. The application of force to the complainant or to a person other than the complainant. Sub B. Threats or fear of the application of force to the complainant or to a person other than the complainant. Sub C. Fraud. Or Sub D. The exercise of authority. Subsection 4. Where an accused alleged that he believed that the complainant consented to the conduct that is the subject matter of the charge, a judge, if satisfied that there is sufficient evidence and that, if he believed by the jury, the evidence would constitute a defense, shall instruct the jury, when reviewing all the evidence relating to the determination of the honesty of the accused's belief, to consider the presence or absence of reasonable grounds for that belief. It can be seen from this brief overview that the absence of consent to intentionally applied force was a material component of the offense of assault throughout its existence in Canada. But it is also evident that consent would not be legally effective in all circumstances. For instance, it would be vitiated by fraud. Various limitations on the validity of consent have long lineage in the history of the offense. To observe those limitations, one must advert to the common law. Yet, before turning to that jurisprudence, it is important to note the link between the offense of assault and the offense of manslaughter, since Jobidon was convicted of the latter offense. 2. The nexus between assault and manslaughter. The connection between the two offenses of assault and manslaughter is found in Section 222, formerly Section 205 of the Code. That section provides a definition of manslaughter which is contingent on an unlawful act causing death. Section 222, Sub 4. Culpable homicide is murder or manslaughter or infanticide. Sub 5. A person commits culpable homicide when he causes the death of a human being. Sub A. By means of an unlawful act. The offense of assault is a foundation offense upon which other offenses against a person are constructed. Of course, an assault is also unlawful. It therefore follows from Section 222 that when an assault is committed and causes the death of a person, the assailant is thereby criminally liable for manslaughter. It also follows that if consent acts as a defense to assault, it will indirectly act as a defense to a charge of manslaughter based on assault. 3. The role and scope of consent in assault. The controversy in this appeal stems from the apparent contradiction between the holding of the Ontario Court of Appeal in the instant appeal and the wording of Section 265 Sub 1 Sub A. By that wording, once the trial judge had found that the deceased had consented to a fight with Jobidon, it appears that he could not have committed the unlawful act of assault, since Section 265 Sub 2 states a general rule that Section 265 applies to all forms of assault, including assault causing bodily harm. Consequently, given the reference to the absence of consent in Section 265 Sub 1, proof of consent to a fist fight in which force is intentionally applied and which results in bodily harm would seem to serve as a defense for Jobidon. In that way, Section 265 Sub 1 and 265 Sub 2 also appear to support the appellant's position that absence of consent is a requirement to be proved by the Crown beyond a reasonable doubt in each and every instance of assault. This understanding of the burden of proof, as distinct from the issue of universal applicability of the requirement, is not explicitly in Section 265, but has been so interpreted by the courts and is supported by some of the most recent academic literature. Given the prima facie appearance of support for the appellant's position, one might question how the Ontario Court of Appeal could hold that the deceased's consent to a fair fight did not preclude commission of the offense of assault. That question would be well aimed. Provincial courts of appeal have grappled with the issue on numerous occasions in recent years, sometimes arriving at divergent conclusions. Legal academics have experienced similar consternation. One has noted that the present state of the law in Canada is, quote, confusing and conflicting, end quote. Another text states, quote, this area of the law is so nebulous that it is difficult to be very precise, end quote. In 1984, the Law Reform Commission of Canada phrased the problem in more detailed terms. As regards the present law, it is clear that sometimes, in the case of mere touching, consent is a defense and that in general, Where the consent is intended to cause death or serious harm, consent is no defense. It is also clear that even in circumstances going beyond mere touching, for example, in surgical operations and in lawful sports, consent can prevent the force from being unlawful. What is unclear is the extent to which the same rule applies or does not apply in Canada outside the operating theatre and the sports arena, for example, in sadomasochistic circumstances. It is the purpose of the remaining analysis to clarify the role of consent in relation to a fistfight or brawl. A. The general influence of the common law on the Code's definition of assault. Although containing myriad provisions of a relatively detailed nature, the Criminal Code has been inspired by general principles of criminal responsibility. Section 265 is no exception. It speaks in universal tone and sets out a general rule that one cannot commit assault if the other person agrees to the application of force. However, while it is true that the general rule says all forms of assault are covered by the various clauses of Section 265, it does not attempt to define the situations or forms of conduct or eventual consequences which the law will recognize as being valid objects of consent for the purpose of the offense. It does not attempt to define the situations in which consent will or will not be legally effective. The present code is silent in this regard. The original statutory definition of assault did not define consent except to indicate the long-standing rule that a fraudulently induced consent is legally ineffective. That traditional common law rule, and its incorporation in the first statutory definition of assault, is explained by Watt at page 219 and is examined in greater detail below. Later statutes also omitted full definitions of consent. The 1983 amendments defined consent only in part by negatively indicating a few ways consent could be vitiated. If Parliament had sought to perform the comprehensive task of indicating what one could and could not consent to, it likely would have offered more guidance. It is noteworthy that in its revised and enlarged report on recodification, the Law Reform Commission of Canada had suggested that consent be defined in definitions section of a new code. Parliament could have specified whether the term consent is aimed simply at the kind of activity being purportedly consented to, here a fistfight, or whether it refers to consent to a trivial injury which does not amount to bodily harm, such as might be sustained in sporting activities, or whether for the defense to apply the consent must be to the precise extent of harm actually caused by the application of force. At any point in the history of the provision, Parliament could have taken the opportunity to specify whether the common law, which already had much to say about assault and the requirement of consent, was being emptied of relevance. But it did not do these things, nor did it have to. Just as the common law has built up a rich jurisprudence around the concepts of agreements in contract law, in volenti non fit injuria in the law of negligence, it has also generated a body of law to eliminate the meaning of consent and to place certain limitations on its legal effectiveness in criminal law. It has done this in respect of assault. In the same way that the common law established principles of public policy negating the legal effectiveness of certain types of contracts in restraint of trade, for example, it has also set limits on the types of harmful actions to which one can validly consent and shelter an assailant from the sanctions of our criminal law. There is no indication in Section 265 that the jurisprudence of the criminal common law was to be undermined by its enactment. There was no hint that traditional policy limits on consent, described below in greater detail, were to be ousted by Section 258 of the First Criminal Code of 1892, nor by enactment of its successor provisions in Section 244, now Section 265. This should not be surprising. As the foregoing sketch of the history of the offense demonstrates, far from intending to curtail the authority of that law, the Code was a partial expression of it. All criminal offenses in Canada are now defined in the Code, Section 9. But that does not mean the common law no longer illuminates these definitions nor gives content to the various principles of criminal responsibility those definitions draw from. As the Law Reform Commission of Canada has noted in its 31st report on recodification, the basic premise of our criminal law, the necessary conditions for criminal liability, are at present left to the common law. The Code itself, in Section 8, explicitly acknowledges the ongoing common law influence. 8 sub 2, the criminal law of England that was in force in a province immediately before April 1, 1955, continues in force in the province except as altered, varied, modified, or affected by this Act or any Act of the Parliament of Canada. Sub 3. Every rule and principle of the common law that renders any circumstances a justification or excuse for an act or a defense to a charge continues in force and applies in respect of proceedings for an offense under this Act or any other Act of Parliament, except insofar as they are altered by or inconsistent with this Act or any other Act of Parliament. Section 8 expressly indicates that the common law rules and principles continue to apply, but only to the extent that they are not inconsistent with the Code or other Act of Parliament and have not been altered by them. While little judicial analysis of this section of the Code has been undertaken, the references made to it have predominantly concerned exceptional circumstances which provide defenses or which deny certain features of an offense. This court's leading interpretation of Section 8 sub 3 is found in Kersner and the Queen, where Laskin Chief Justice expressly rejected a static view of the common law under Section 8 sub 3, formerly Section 7 sub 3. Though speaking in the context of alleged prosecutorial impropriety, a claimed defense of entrapment, Chief Justice Laskin offered an expensive developmental view at page 496. There are good reasons for leaving the question open. Indeed, if that position is based on a static view of Section 7 sub 3 of the Criminal Code, I find it unacceptable. I do not think that Section 7 sub 3 should be regarded as having frozen the power of the courts to enlarge the content of the common law by way of recognizing new defenses. The approach of the Chief Justice in Kersner was later reinforced in a motto in the Queen. Writing in dissent on behalf of Chief Justice Laskin, Justices McIntyre and Lamar, Justice Etsy applied what he termed the, quote, ordinary rule of construction where statutes and common law meet, end quote, and concluded that, quote, Section 7 sub 3 is the authority for the courts of criminal jurisdiction to adopt, if appropriate in the view of the court, defenses including the defense of entrapment, end quote. The court's majority did not disagree with this determination. In reasoning to that conclusion, Justice Etsy made the following comments at page 443. The conventional view has been that the common law is always speaking. Some theories hold that it is a process of discovery, others of evolution. Whatever it might properly be classified to be in the jurisprudence, it would take the clearest and most precise language in a statute which purports to incorporate the principles of common law to so construe it as to crystallize the common law at the date of the enactment of the statute. If so, the importation of common law principles would be limited to those which had crystallized and developed prior to the effective date of the statute. Section 7 sub 3 does not employ such words. It is at most ambiguous, susceptible either to the static view or to the view that it makes reference to a common law as an evolving, developing system of rules and principles. Where a statute might read as displacing the common law, the appropriate canon of interpretation is a preference for the construction which preserves the rule of common law where it can be done consistently with the statute. Justice Etsy also referred extensively to Section 19 of the Report of Imperial Commissioners of the Draft Code of 1879, which is the forerunner to the present Section 8 sub 3. In a motto, they are quoted as explaining their inclusion of the section in these terms. But whilst we exclude from the category of indictable offences any culpable act or omission not provided for by this or some other Act of Parliament, there is another branch of the unwritten law which introduces different considerations, namely, the principles which declare that circumstances amount to a justification or excuse for doing that which would have otherwise been a crime, or at least would alter the quality of the crime. In the case of ordinary occurrence, the decision of the courts and the opinions of great lawyers enable us to say how the principles of the law are to be applied. In light of this communicated understanding of the antecedents and the purposes of Section 8 sub 3, it can hardly be said that the common law's developed approach to the role and scope of consent as a defense to assault has no place in our criminal law. If Section 8 sub 3 and its interaction with the common law can be used to develop entirely new defenses not inconsistent with the code, it surely authorizes the courts to look to pre-existing common law rules and principles to give meaning to and explain the outlines and boundaries of an existing defense or justification, indicating where they will not be recognized as legally effective, provided, of course, that there is no clear language in the code which indicates that the code has displaced the common law. That sort of language cannot be found in the code. As such, the common law legitimately serves in this appeal as an archive in which one may locate situations or forms of conduct to which the law will not allow a person to consent. Of course, this general analysis does not answer all of the appellant's arguments to the contrary. Responding to them requires a more directed focus on the specific conjunction of the code and the common law in fistfight type situation. The specific relationship between the code and the common law of assault in cases of fistfights. 1. Relationships between consent and Section 265 sub 3. The appellant argued that in the 1983 amendments to Section 265 reflected Parliament's intent to replace any common law doctrines that might have negated the legal effectiveness of consent to an act which would otherwise constitute assault. In particular, there is reference made to Section 265 sub 3, which sets out 4 factors that may vitiate consent: application of force, threats of force, fraud, or the exercise of authority. It was argued that because Parliament explicitly specified these factors, any others, even though they may have applied prior to 1983, could no longer be drawn from the common law. Since the trial judge found that Haggart had consented to the fight and did not hold that such consent was invalidated on any of the 4 grounds, it should be effective and should serve as a defense to assault as the plain words of Sections 265 sub 1 and 265 sub 2 appear to require. While at first glance the appellant's arguments may seem cogent, it is ultimately unpersuasive. Parliament did not set foot into new territory when listing the 4 vitiating factors in Section 265 sub 3. On the contrary, it will be seen that, for the most part, that list merely concretized and made more explicit basic limits on the legal effectiveness of consent which had for centuries formed a part of the criminal law in England and in Canada. Their expression in the code did not reflect an intent to remove the existing body of common law which already described those limitations and the respective scope. The code just spelled them out more clearly in a general form. That common law is rich and extensive, with roots reaching back well into the decades preceding Canada's adoption of the code in 1982. For instance, it provided that, as a general rule, consent could only be valid or legally effective if it was given freely by rational and sober person. Thus, in the Queen in March 1844, the English Criminal Court, speaking through Lord Tyndale, held that a fraudulently obtained consent to common assault was no consent at all. The parallel in our code is in Section 265 sub 3 sub c. In the Queen and Locke in 1872, an English criminal court held that 8-year-old boys were too young to understand the nature of a sexual act with a grown man to be able to consent to it. Submission by a young child to an older, stronger person, an authority figure, would not be considered consensual. The consent would in all probability have been obtained under a coerced and ill-informed will. This principle now finds expression in Canada in Section 265 sub 3 sub d. As for the consent of the context of fistfights, the English common law displayed a similar penchant for limiting its role as an exculpatory defense. However, it is vital to note that the basis of the concern was different than in the case of fraud, threats, or forced consents. The early cases often did not explicitly acknowledge that different basis, but hints of it may be identified. It was a concern that the offense of assault, more particularly the element of consent, be informed by considerations of public policy. Such considerations were thought sufficiently important to justify nullifying the legal validity of consent as a defense to a charge of assault. For instance, in Wright's case in 1603, the English Criminal Court held that not only would a man be punished for a law procuring another to sever his hand, to assist his career as a mendicant, but the person effecting the task would also be liable to criminal sanction, irrespective of the other's consent. In Matthew and Allerton in 1693, it was held that a man may not license another to beat him as an act amounted to the breach of the peace. This principle was repeated in Boulté and Clark in 1747, where it was determined that it was no defense to a charge of assault that the two persons fought by mutual consent. Justice Coleridge reaffirmed the doctrine in The Queen and Lewis in 1844, a case involving a fight between two men outside of a dance hall, which had resulted in the death of a man from blows sustained to his head. Coleridge J. stated at page 875, "It ought to be known that, whenever two persons go out to strike each other, and do so, each is guilty of an assault. It will be seen that this nullification of the defense of consent in a fist fight cases in England has continued forward uninterruptedly to the present day. In Canada, the same principle was applied for many decades before the appropriateness of such invalidation was ever brought into question. Indeed, it was for reasons of public policy that the Court of Appeal nullified Haggart's consent. We've observed from the general analysis of the Code and common law that, in the history of our criminal law, codification did not replace common law principles of criminal responsibility, but in fact reflected them. That history also reveals that policy-based limitations of the sort at issue here boast a lineage in the common law equally as long as the factors which vitiate involuntary consent. Since these policy-based limitations also existed before the codification of Canada's criminal law, there is no reason to think that they have been ousted by statutory revisions and amendments made to the Code along the way. On this understanding, even if it could be concluded, contrary to my own view of the law, that Section 265 sub 3 negated the applicability of common law rules which describe when a consent to assault will be vitiated for involuntariness, or defects in the will underlying the apparent consent, it would not follow that those amendments erase limitations based on public policy. If Parliament had so intended, it would have stated that intention. As it is, the Code amended in 1983 is entirely silent in this regard. This view accords with the interpretation of the Law Reform Commission of Canada. In its working paper on assault, it notes that, regardless of the wording of Section 265 sub 3, not all consents will be accepted as being legally effective. Irrespective of a finding of real or implied consent in some cases, resembling the situation in the instant appeal, quote, the victim's consent or non-consent is quite irrelevant, end quote. It cites as to one example at page 6 the situation where the application of force is intended to cause death or serious bodily harm, and another when a blow is struck in the course of an illegal fight, end bracket. That irrelevance is the result of policy considerations in which some circumstances nullify the legal effectiveness of consent. Furthermore, since Section 8 sub 3 of the Code expressly confirms the common law's continued authority and provides that the exculpatory defense is not expressly struck down by the Code continue to operate to exclude criminal liability, in this appeal, where the Code has not erased the common law limit in fistfights, it must continue to define the scope of legally effective consent. Some may object that Section 8 sub 3 cannot be used to support this interpretation because consent is not really a defense, but instead forms part of the offense. Indeed, it is the absence of consent that is relevant as an element of the offense of assault. For example, Mewett and Manning, cited at page 567, write that, quote, real consent, therefore, is an essential element of assault going to the actus reus in the sense that if consent is present, no offense can have been committed, end quote. Yet, while that objection may have some relevance from a strictly formalistic perspective, it is of little consequence from a substantive point of view. Moreover, it conflicts with the spirit of this court's previously expressed understanding of Section 8 sub 3. Whether consent is formally categorized as part of the actus reus of the offense or as a defense, its essential function remains unaltered. If consent is proved, or if absence of consent is not proved, an individual accused of assault will generally be able to rely on the consent of the complainant to bar a conviction. He will be able to lean on the consent as a defense to liability. This basic reality has been widely recognized. English and Canadian courts widely refer to consent as being in the nature of a defense. Leading treatises on criminal law conceive it this way. We have also observed in the general interpretive section above that the law confers on Section 8 sub 3 an open and developmental view of the common law's role. Section 8 sub 3 strongly suggests preservation of the common law approach to consent in assault. Assault has been given a very encompassing definition in Section 265. It arrives whenever a person intentionally applies force to a person quote, directly or indirectly, end quote, without the other's consent. The definition says nothing about the degree of harm which must be sustained, nor does it refer to the motives for the touching. If taken at face value, this formulation would mean that the most trivial intended touch would constitute an assault. As just one of many possible examples, a father would assault his daughter if he attempted to place a scarf around her neck to protect her from the cold, but she did not consent to that touching, thinking the scarf ugly or undesirable. Bracket. Even an argument for implied consent would not seem to apply in a case like this, end bracket. That absurd consequence would not have been intended by Parliament. Rather, its intention must have been for the courts to explain the content of the offence incrementally and over the course of time. Furthermore, whereas the factors applied in section 265 sub 3 are readily identifiable and are generally applicable to all sorts of situations, that is inherently not true of limitations based on policy considerations, which are fact-specific by nature. It would have been quite impractical, if not impossible, for Parliament to establish an adequate list of exceptions to apply to all situations, old and new. Policy-based limits are almost always the product of a balancing of individual autonomy, bracket, the freedom to choose to have force intentionally applied to oneself, and bracket, and some larger societal interest. That balancing may be better performed in the light of actual situations, rather than in the abstract, as Parliament would have been compelled to do. With the offence of assault, that kind of balancing is a function the courts are well suited to perform. They will continue to be faced with real situations in which complicated actions and motivations interact, as they have in the past. I do not accept that the argument by failing to enact a list of objects or a form of conduct to which one could not validly consent, Parliament intended to eliminate the role in the offence of assault and to rely only on the 4 factors specified in section 265 sub 3. Such a major departure from well-established policy calls for more than mere silence, particularly as such a list would have been unduly difficult and impractical to prescribe, and was unnecessary given their existing entrenchment in the common law. The common law is the register of the balancing of functions of the courts. A register Parliament has authorized the courts to administer in respect of policy-based limits on the role and scope of consent in section 265 of the Code. 2. The relationship between consent in section 265 sub 2. The appellant argues that the interpretation favoring limits on consent being advanced here would render section 265 sub 1 sub a, without the consent of another, otiose and meaningless, insofar as section 265 sub 2 specifies that section 265 sub 1 sub a is to apply to all forms of assault, including assault causing bodily harm. However, this objection is not sustainable. By specifying in section 265 sub 2 that section 265 is to apply to all forms of assault, Parliament undoubtedly sought to ensure the basic elements of the offence of assault in sections 265 sub 1 and sub a to sub c, the circumstances listed in section 265 sub 3 for vitiating consent due to a coerced or misinformed volition, and the required state of mind for raising a defense in section 265 sub 4 would be applied without exception, irrespective of the peculiar form of assault. That is plain. Yet it does not follow that from the expression that Parliament intended to eliminate the common law prescription of objects or forms of conduct to which legally effective consent may not be given. Section 265 was deliberately left open in that regard, for the above reasons. Section 3. Consent in Section 14 of the Code. Section 14 nullifies consent to the infliction of death in a broad and open-textured fashion. It provides, Section 14, no person is entitled to consent to have death inflicted on him, and such consent does not affect the criminal responsibility of any person by whom death may be inflicted on the person by whom consent is given. A final argument made by the appellant is that by enacting Section 14 of the Code, Parliament reflected its intention to negate consent solely in situations where death was intended to be caused. With other situations, and with forms of conduct like the fistfight between Jobidon and Haggart, where the consequence was not intended, consent should be given full legal effect. In other words, the appellant suggested a version of the interpretive principled expression by the maxim expressio unius est exclusio alturius, but this argument also fails. Section 14 is an absolute exclusion of consent to death in all circumstances. It follows neither from logic nor from the structure of the code that, absent death, consent to any or all forms of bodily injury is permissible, regardless of the circumstances. The section speaks only of consent to the infliction of death. It does not comment on consent to other consequences, any more than it comments on sexual offenses or any other form of assault. It stands on its own. C. Common law limits to fistfights and brawls. Limits on consent to assault have been long recognized by English and Canadian courts. We have already seen the earlier antecedents of them in the English jurisprudence, in fistfights and otherwise. Here we are concerned only with the former situation. In present times as well, the English courts have on the whole been very consistent when confronted by assaults arising from fistfights and brawls. Since the English cases have set the overall direction for the Canadian common law in the assault context, and apparently continues to do so, it is of particular relevance in the circumstances of this case. The Canadian authorities also favor limits on consent. However, in recent years there has evolved a mixed record across provincial courts of appeal. This appeal, therefore, presents a timely opportunity for clarification. 1. The English authorities. We have seen that the readiness of the common law to constrain the role and effectiveness of consent in cases of assault may be identified as far back as 1603, and it runs well into the 19th century, but that willingness did not suddenly cease in the late 1800s. The springboard for the modern authorities was the decision of the English Court of Queen's Bench in the Queen and Coney, 1882. 11 judges held that a prize fight was illegal and that all persons aiding and abetting the fight were guilty of assault. For public policy reasons, differently expressed by various members of the court, consent of the fighters was held to be ineffective. The essence of the court's justification was that the consensual fistfights tend to encourage public disturbances and breaches of the peace and should not be condoned by the criminal law. The view is expressed by Justice Stephan at page 549 that when one person is indicted for inflicting personal injury upon another, the consent of the person who sustained the injury is no defense to the person who inflicts the injury, if the injury is of such nature, or is inflicted under such circumstances, that its infliction is injurious to the public as well as to the person injured. The English Court of Criminal Appeal had an opportunity to build on Coney in the Queen and Donovan in 1934. The accused had beaten a 17-year-old girl with a cane but denied he was guilty of indecent and common assault on the ground that the girl had consented to the beating. At certain points in its judgment, the court seems to determine the issue on a factual basis, namely that the victim did not actually consent. Nonetheless, it chose to pronounce its decision in these terms, as per Justice Swift at page 210. As a general rule, although it is a rule to which there are well-established exceptions, it is an unlawful act to beat another person with such a degree of violence that the infliction of bodily harm is a probable consequence, and, when such an act is proved, consent is immaterial. Finally, in 1980, the English Court of Appeal was asked to state the law in Attorney General's reference. It was a reference prompted by a street fight between two young men who, in a relatively calm fashion, had decided to settle differences between them by resorting to their fists. One suffered a bleeding nose and some bruises. The other was charged with assault, but acquitted. The question put to the appellate court was, where two persons fight, bracket, otherwise than in the course of sport, end bracket, in a public place, can it be a defense for one of those persons to a charge of assault arising out of the fight that the other consented to the fight? The court held that because it is not in the public interest that people should cause each other bodily harm for no good reason, consent is no answer to a charge of assault when, quote, actually bodily harm is intended and or caused, end quote. This meant that most fights would be unlawful regardless of consent. Only minor struggles, or rough but properly conducted sporting events, which may have some positive social value, were combative activities where consent would be an effective bar to the charge of assault. Of course, lawful chastisement and reasonable surgical inference were also activities in which the public interest does not require nullification of consent. In such cases, the general rule applies. The Crown must prove absence of consent to get a conviction for assault. The English Court of Appeal added that the public nature of the forum in which the fight occurs is not determinative of the effectiveness of consent. Private fights deserved no more protection than public ones. If determinative of this appeal, the English authorities would undoubtedly support the decision of the court below. Here the assault occurred in circumstances which appear very nearly to have amounted to a disturbance of the peace, and there is no question that the punches thrown by Jobidon were intentionally applications of force intended to cause the deceased bodily harm. Rodney Haggart's apparent consent would have provided no defense to Jobidon in England. 2. The Canadian authorities. We have seen that the statutory definition of assault has always contained a general requirement that the Crown prove absence of consent, and has made reference to some circumstances in which consent would be considered involuntary. But this court has not previously confronted the precise issue on appeal. Provincial appellate courts, on the other hand, have dealt with numerous cases of purported consensual beatings or fights giving rise to a charge of assault, and sometimes manslaughter, though the overwhelming bulk of these have surfaced in recent times. Prior to the 1970s, only one reported decision squarely addressed the issue, the Queen and Buchanan, decided a few years after the offense was incorporated into the Code of 1892. Sitting in appeal, the Manitoba Court of Queen's Bench accepted the principle stated in Coney that consent to assault should be ineffectual in the context of fistfights where bodily harm is intended. The court held that a blow landed in a fistfight amounted to an assault regardless of consent, citing the following passage from Coney. The true view is that a blow struck in anger, or which is likely or is intended to do corporal harm, is an assault, but that a blow struck in sport and not likely, nor intended to cause bodily harm, is not an assault, and that, an assault being a breach of the peace and unlawful, the consent of the person struck is immaterial. The Coney principle was reconfirmed en passant by the Court of Appeal in Bradley and Coleman, a fistfight case, in which dealt with unilateral aggression in a rape. But the issue was not again squarely addressed as it had been in Buchanan until the late 1970s, where the earlier view became seriously disturbed. Provincial courts of appeal began rendering statements which appeared to directly contradict Buchanan and the English approach in Coney and Donovan. Indeed, the first appeals either ignored the English jurisprudence completely or discounted its applicability to the Canadian statutory assault provisions. As for Buchanan, it was entirely absent from the court's deliberations. In 1972, the Appeal Division of the New Brunswick Supreme Court rendered its decision in the Queen and McTavish, a case in which two boys got into a schoolyard fight that ended when one boy sustained a broken nose from kicks landed by the other. The court simply assumed that consent was an operative defense to a charge of assault under then Section 244 of the Code, the onus being on the Crown to prove absence of consent beyond a reasonable doubt. However, in strict terms, that view was Obiter because, on the facts, while the injured boy had consented to a, quote, fair fight, he had not consented to have, quote, his head kicked in. He had not agreed to have that kind of force inflicted on him, nor had he agreed to that particular form of activity. The court upheld the conviction on the basis, not on the ground, that defense of consent must, in all situations, be legally effective. Ontario's appellate court joined New Brunswick's approach in the Queen and Dix. The court faced a situation partly similar to the one here. A scuffle occurred in a beverage room. The two men went outside the premises to fight, with the consequence that the complainant was severely injured. The trial judge convicted the accused of assault causing bodily harm. The Court of Appeal stated its legal opinion in unequivocal terms. There is no doubt that the Crown proved that the accused intentionally applied force to his victim, and thereby caused bodily harm to him, but the intentional application of force does not amount to an assault unless the force was applied without the victim's consent. The judge found that there was consent, in the sense that the two persons involved agreed to fight. The onus was on the Crown, as it seems to us, to satisfy the judge that what the appellant did was beyond the scope of the consent that had been given. The appellate court overturned the conviction on the grounds stated by Chief Justice Gale at page 32526 that, quote, the Crown failed to prove the necessary element of lack of consent to that which was done. The two parties consented to a fight, and the fight was had in a normal manner, if I might use that phrase, end quote. In The Queen and Abraham in 1974 was the next in the growing series of decisions in which then Section 244 was read to require the Crown to prove absence of consent, this time to a charge of common assault of a man's wife, through punches and kicks to her head and by pulling her hair on a public street. The Quebec Court of Appeal held that the accused had been wrongly precluded from raising a consent as a defense to the charge at his trial, notwithstanding that the assault may have constituted a breach of the peace. As per Justice Gagnon, Section 244 of the Criminal Code makes the absence of the victim's consent an essential ingredient of the crime of assault, and this ingredient must be established by the prosecution beyond all reasonable doubt. It appears to me that because of this statutory particular, the English case law on this point must be accepted with caution. Finally, I do not believe that the accused is precluded from pleading consent by the fact that an assault may constitute a breach of the peace. Having registered this view, the court proceeded to uphold the conviction on the ground that even though the accused should have been permitted to raise the issue, the facts could not have supported a finding of consent. As in McTavish, in strict terms, the court's statements about the applicability of the defense of consent were obiter dicta. A fourth province added its voice in this developing chorus in The Queen and Setram. The Saskatchewan Court of Appeal confronted a situation in which a fight had erupted between two men outside the residence in which they had been drinking. As in the case at bar, the fight ended in the death of one of them. The trial judge had relied on Coney and Donovan to hold that a fight by consenting parties was unlawful assault, per se, regardless of consent. The Saskatchewan Court of Appeal directly rejected the interpretation after a close examination of the terms of Section 244 of the Code, and after reviewing and agreeing with the author of Tremier's Annotated Criminal Code, who, following an explosion of the English cases, concluded, "It is, however, very doubtful in the view of the wording of the Code whether there can be in any circumstances be an assault where the person assaulted has consented, unless that consent has been obtained by fraud." Finally, drawing on Dix and Abraham, the court had this to say: "The language defining assault makes it absolutely clear that the proof of lack of consent to the assault is an essential element which must be proved if a conviction is to be found. The instruction that a fight by consent per se was an unlawful act was wrong in law." With this interpretation in hand, the Saskatchewan court allowed Struyman's appeal of the conviction for manslaughter and ordered a new trial. Seatram was followed by Cregan J. of the New Brunswick Court of Queen's Bench in The Queen and Cruz. If the preceding line of authority were singularly determinative of the common law binding this court, there should be little question about the result called for here. Given the finding of consent by the trial judge, Jobidon would not have committed the offense of assault. But the path is by no means as straight and as clear as these cases seem to indicate. Since Setram, certain decisions have in varying degrees pulled away from that bright line, absolutist approach, which more or less ignores the traditional view of consent in fist-fight cases. The respondent relies on some of these more recent decisions when claiming that McTavish, Dix, Abraham, and Setram lines should not be followed. While some of the most recent decisions are consistent with that chain of cases, others take due note of the established common law policy to insist that fistfights are special situations which call for some limits on the effectiveness of the element of consent in Section 265. There are, of course, shades of opinion as to the most appropriate place to draw protective lines in different situations. Although dealing with homicide and the defense of provocation, the Ontario Court of Appeal and the Queen and Squire found occasion to rely on both Coney and Donovan to conclude that the mere fact of consent between two persons to administer blows to one another did not, of itself, make such blows lawful, as per Justice Martin, stating at page 230, "Where two persons engage in a fight in anger by mutual consent, the blows struck by each constitute an assault on the other, unless justifiable in self-defense in accordance with the provisions of the Code." The Supreme Court of the Northwest Territory staked out the same interpretive ground in the Queen and Cassuge. In a case dealing with the Section 244 offense of causing bodily harm with intent to wound, the judge held that a man who had intentionally applied force to another while trying to break up a fight was guilty of the included offense of assault causing bodily harm. Justice Marshall found occasion to stress at page 247 that it was the policy of the law that one cannot validly consent to a touching that is, quote, intended to truly injure, end quote. He noted that the law had long discouraged this brand of, quote, self-help, and should instead to deter violence and breaches of the peace. The Nova Scotia Court of Appeals supported these views in the Queen and Gur. There, the accused and the victim had been armed with knives and fought with them in the victim's house. The complainant had sustained serious cuts to his hands. Inter alia, the accused was charged with unlawfully using a weapon and committing an assault contrary to then Section 245.1 of the Code. The accused invoked the consent of the victim as his primary defense. After stating that the Code had not negated the applicability of the common law in the assault context, and relying on the trio of English cases, the court distinguished McTavish, Dix, and Abraham and Setram on the basis that they had dealt with assault charges arising out of fistfights, not the use of dangerous weapons. In coming to its conclusion that the trial judge had erred in the instructing of the jury that consent was a defense to the charge, and relying heavily on Attorney General's reference, the Nova Scotia Court stated its interpretation of the law in direct and open-ended terms, as per Justice Jones at page 518. As it is an offense to commit an assault where bodily harm is intended or caused, then consent cannot be a defense to using weapons for the purpose of committing an assault. I cannot agree that a person can consent to the infliction of bodily harm that results in death. This approach was more broadly applied by the Nova Scotia Supreme Court Appeal Division in the Queen and Mackintosh. The sole issue in that appeal was whether a participant in a fistfight can legally effectively consent to the intentional infliction of bodily harm upon himself. After reviewing the relevant jurisprudence, the unanimous court, speaking through Justice MacDonald, concluded that it was because it was not in the public interest that people should try to cause each other actual bodily harm for no good reason. Most fights would be unlawful regardless of consent. In fairly quick succession, the Alberta Court of Appeal was thrice required to grapple with this issue in the Queen and Carey, then in Queen and Bergner, and then most recently in the Queen and Loonskin. In the Queen and Carrier, two women engaged in a fistfight in the lobby of a hotel. Stopped briefly and moved outdoors, the fight was renewed in the parking lot, this time with knives. The victim sustained a stab wound in her abdomen. The accused was charged and convicted of aggravated assault contrary to then Section 245.2 of the Code. The Court of Appeal upheld that conviction. In delivering the judgment of the court, Chief Justice Laycroft stated unequivocally that the English cases demonstrated a definite rule that a victim's consent provided no defense where, quote, where the assault maimed the victim, end quote. He noted that Professor Williams had suggested that in modern times the rationale of the rule may be that the victim will likely become a public charge, contrary to the public interest. With lesser forms of bodily harm, Chief Justice Laycroft conceded that Canadian authorities reflected a considerable diversity of opinion. So, although he acknowledged that, quote, fists are not insignificant weapons, end quote, and that fistfights often end in serious injury or death, he restricted his holding to the narrower issue before the court, concluding at page 269, I have, however, no doubt of the answer which the law must reach in a fight with knives where the charge is under one of the assault sections. One cannot consent to be stabbed. The public policy of the law intervenes to nullify the apparent consent of each of the combatants. Before completing his judgment, Chief Justice Laycroft commented, in passing, that some cases dealt with under assault sections of the Criminal Code might be better handled by charges of criminal negligence. In the Queen and Bergner, heard later in the same year, the court was given the chance to decide the issue of fistfights on which it had refrained from commenting on Carrier. The accused, Bergner, had been charged with assault causing bodily harm, arising from a fight initiated in a hotel bar and continuing outside onto the street. Bergner hit the inebriated complainant repeatedly in the stomach and the face with his fist, and then kicked the complainant's face and ribs with his boots. The complainant suffered a fractured nose and cheekbone, as well as damage to an optic nerve which left him blind in one eye. The trial judge held that it was a consensual fistfights and on that basis acquitted Bergner of assault causing bodily harm. Chief Justice Laycraft again noting that in Canada, cases of consensual fistfights show considerable variation in both result and rationale. Due to that indeterminacy, Chief Justice Laycraft thought himself obliged to allow policy considerations to decide the issue. In the end, he determined that consent to fistfights should not be nullified on the basis of the tests of, quote, blow struck in anger, end quote, and where, quote, actual bodily harm is intended and or caused, end quote. Even when intentional bodily harm was caused, in his opinion, the extent of such nullification would be overly encompassing. It would invalidate too many consents in numerous activities. If in anger or the intention to do corporal hurt or to truly injure or to cause actual bodily harm is to trigger the intervention of public policy in so nullifying consent, it is difficult to imagine the case in which there would be no such intervention. Schoolboys in a disagreement, with or without boxing gloves, intend and strive mightily to injure or cause bodily harm. They are certainly angry. Even professional boxers fighting for money may not be able to resist the onset of a certain choler. The contestants in fights in hockey or football also meet all the criteria. The friendly fight is a rare phenomenon. The express tests do not, in my respectful opinion, focus on one of the elements which should be even more quickly induce the public policy of the law to nullify consent. Bracket, the fact that in most fistfight challengers are often large, trained bullies, and genuine consent to the other person is dubious at best, end quote. Having rejected these tests for fistfight cases, Chief Justice Laycraft stated that once consent to a fistfight is truly established, it will preclude conviction for assault. Unlike fights with weapons, it would be too difficult and bordering on judicial usurpation of political authority to formulate a code of tests for nullifying the consent of weaponless fighters based on anger or intent to cause bodily harm. Thus, even though it disagreed with the trial judge's factual findings of consent, the Court of Appeal regretfully dismissed the Crown's appeal. Provincial appellate courts have thrice been asked to interpret the role of consent in assault-based offences after Bergner. In the Queen and Loonskin, the Alberta Court of Appeal followed the approach it established in Bergner. It held that, while the Crown was required by Section 265 to prove absence of consent to ground a conviction of aggravated assault, on the facts of the case before it, where one of the combatants in a fistfight had bitten off the part of the other's ear, consent had in fact not been given. Any consent to a fight in general was exceeded by the extent and force of the accused's harmful conduct. The court took the opportunity to emphasize that while a legal defense of consent exists, nevertheless truly consensual fights would be very rare, quote, where one person attacks and another defends, and even in many cases where a challenge is met by a defense, it is not realistic to speak of a consensual fight, end quote. In overturning the acquittal, the Court of Appeal distinguished Bergner on the grounds that in Bergner it was easier to find as a matter of fact that the combatants had consented to a fight, because they deliberately moved from one place to another with the express intention of settling their differences by combat. Not so in Loonskin, where the fight had erupted rather spontaneously and without agreement that bites would be involved. Having not faced this issue of consent since the decision in Setram, the Saskatchewan Court of Appeal returned to it in the Queen and Say, apparently with a very different mindset. Say involved a charge of assault and causing severe bodily harm under Section 245.1 of the Code for injuries sustained in a hockey game when the accused stick-checked the complainant in the face and neck. The complainant suffered injuries to his head and was found to have sustained a concussion and a whiplash, keeping him hospitalized for 3 days. The trial judge found that the accused had not intended to injure the complainant, nor had he intended to apply any greater force to the victim than was customary in the game. Since the complainant had continued to play the game after he received the injuries, the trial judge held that the willingness amounted to an implied consent to bodily contact which had occurred and used that finding as the basis for acquitting the accused. The Crown appealed on the partial ground that the trial judge had misdirected himself on the issue of consent. Without referring to Setram, the majority in Say came to its conclusion by relying on Attorney General's reference and the Ontario Court of Appeal's decision in the case at bar, both cases having been decided subsequent to earlier decision in Setram. To that extent, the reasoning in Say is as much at stake in this appeal as that of the Ontario Court of Appeal below. The Saskatchewan Court of Appeal held that, although consent to the application of force may be implied, and may thereby constitute a valid and effective consent, nonetheless its effective scope is limited, and not only by circumstances, but also by the law. At pages 492 and 93, the trial judge, if he found either express or implied consent, was, in my view, required to consider whether the nature of the act was such that the victim could, in law, consent to it. I am in agreement with the analysis of the term assault and the limits for a victim to consent thereof in the decision of the Ontario Court of Appeal in the Queen and Jobidon. While the Jobidon case dealt with a consensual fight outside a bar, and while the English reference case referred to an activity outside of a sport, I see no reason in principle why the consent, expressed or implied, to assault in the context of a sporting event should not be considered similarly. That is, in the sporting events, as well in mere fact that a type of assault occurs with some frequency does not necessarily mean it is not of such a severe nature that consent thereto is precluded. In a sport such as hockey, however, I believe that the test may be more limited than in the Attorney General's reference case. That is, I think, the alternate reference to, quote, caused to be inappropriate where actions to which there is implied consent may be extraordinary circumstances causing harm. Since the trial judge had not directed himself to the nature of the act impliedly consented to, the acquittal was set aside. D. Summary of the common law. 1. The English position. Attorney General's reference makes it clear that a conviction of assault will not be barred if, quote, bodily harm is intended and or caused, end quote. Since this test is framed in the alternative, consent could be nullified even in situations where the assailant did not intend to cause the injured person bodily harm but did so inadvertently. In Canada, however, this very broad formulation cannot strictly apply, since the definition of assault in Section 265 is explicitly restricted to intentional application of force. Any test in our law which incorporated the English perspective would, of necessity, have to confine itself to bodily harm intended and caused. 2. The Canadian position. The preceding analysis reveals division in the Canadian jurisprudence. Decisions by courts of appeal in Manitoba, Ontario, Nova Scotia, and lately Saskatchewan would nullify consent to intentionally inflicted bodily harm arising from a fistfight. Their approach is contained, respectively, in Buchanan 1898, Collin 1948, Squire 1975, Jobidon 1988, Gurr 1986, McIntosh 1991, and Say in 1989. Bracket. There is of course general support for the idea of policy-based nullification in the Alberta Court of Appeal. Witness the language of Chief Justice Laycroft in the Queen and Carey. End bracket. On the other side are decisions of the appellate courts in New Brunswick, McTavish, in Quebec, Abraham, in Saskatchewan, Setram, in Alberta, in Bergner and Loonskin. Although there is certainly no crystal clear position in the modern Canadian common law, still, when one takes into account the combined English and Canadian jurisprudence, when one keeps sight of the common law's centuries-old persistence to limit the legal effectiveness of consent to a fistfight, and when one understands that Section 265 has always incorporated that persistence, the scale tips rather heavily against the validity of a person's consent to the infliction of bodily injury in a fight. The thrust of the English common law is particularly important in this regard because it has been consistent for many decades, indeed centuries. It became an integral component of the Canadian common law and has remained so to this day. Many of the seemingly pivotal pro-consent decisions made by courts in the 1970s were either obiter or were pronounced upon insufficient consideration of the important role of the traditional common law. Moreover, they were decided prior to the decision in Attorney General's reference, which offered a very authoritative pronouncement of the common law position. The significance of that decision is perhaps best indicated in the instant appeal, for it provided the basis used by the Ontario Court of Appeal to overrule its decision in the Queen and Dix. The Attorney General's reference case was again observed to be pivotal in the recent decision of the Appeal Court of Saskatchewan and the Queen and Say. In light of these many considerations, I am of the view that the Canadian position is not as opaque or bifurcated as one might initially think. Notwithstanding this conclusion, given the residual indeterminacy which immediately lingers in the recent Canadian cases, it is useful to canvass policy considerations which exert a strong influence in this appeal, for they rather decisively support the respondent, bringing down the scales even more surely in support of the decision in the court below. E. Policy considerations. Foremost among the policy considerations supporting the Crown is the social uselessness of fist fights. As the English Court of Appeal noted in the Attorney General's reference, it is not in the public interest that adults should willingly cause harm to one another without a good reason. There is precious little utility in fist fights or street brawls. These events are motivated by unchecked passion. They so often result in serious injury to the participants. Here it resulted in a tragic death to a young man on his wedding day. There was a time when pugilism was sheltered by the notion of chivalry. Dueling was an activity not only condoned, but required by honor. Those days, fortunately, are long past. Our social norms no longer correlate strength of character with prowess at fisticuffs. Indeed, when we pride ourselves for making positive ethical and social strides, it tends to be on the basis of our developing reason. This is particularly true of the law, where reason is cast in a privileged light. Erasing long-standing limits on consent to assault would be a regressive step, one which would retard the advance of civilized norms of conduct. Quite apart from the valueless nature of fistfights from combatants' perspectives, it should also be recognized that consensual fights may sometimes lead to larger brawls and to serious breaches of the public peace. In the instant case, this tendency was openly observable. At the prospect of a fight between Jobidon and the deceased, in a truly macabre fashion, many patrons of the hotel deliberately moved to the parking lot to witness the gruesome event. That scene easily could have erupted into more widespread aggression between allies of the respective combatants. Indeed, it happened that the brothers of Jobidon and Haggart also took to each other with their fists. Given the spontaneous, often drunken nature of many fistfights, I would not wish to push a deterrence rationale too far. Nonetheless, it seems reasonable to think that, in some cases, common law limitations on consent might serve some degree of deterrence to these sorts of activities. Related to a deterrence rationale is the possibility that, by permitting a person to consent to force inflicted by the hand of another, in rare cases the latter may find he derives some form of pleasure from the activity, especially if he is doing it on a regular basis. It is perhaps not inconceivable that this kind of perversion could arise in a domestic or marital setting where one or more of the family members are of frail or unstable mental health. As one criminal law theorist has written, the self-destructive individual who induces another person to kill or to mutilate him implicates the latter in the violation of a significant social taboo. The person carrying out the killing or the mutilation crosses the threshold into a realm of conduct that, the second time, might be more easily carried out. And the second time, it might not be particularly significant whether the victim consents or not. Similarly, if someone is encouraged to inflict a sadomasochistic beating on a consenting victim, the experience of inflicting the beating might loosen the actor's inhibitions against sadism in general. Of course, this appeal does not concern sadism or intentional killing, but it comes close to mutilation. In any event, the weight of the argument could hold true for fights. If aggressive individuals are legally permitted to get into consensual fistfights, and they take advantage of that license from time to time, it may come to pass that they eventually lose all understanding that the activity is the subject of a powerful social taboo. they may too readily find their fists raised against a person whose consent they forgot to ascertain with full certitude. It is preferable that these sorts of omissions be strongly discouraged. Wholly apart from deterrence, it is most unseemly from a moral point of view that the law would countenance, much less provide a backhanded sanction to the sort of interaction displayed by the facts of this appeal. The sanctity of the human body should militate against the validity of consent to bodily harm inflicted in a fight. Some would say the offensive assault should not be concerned with these considerations. They might argue that in respect of street fights, deterrence and express disapprobation of the law is already contained in other provisions of the criminal code. For instance, Parliament has seen fit to prohibit, quote, prize fighting on penalty of criminal sanction in Section 83. However, while it is true that Section 83 prohibits prize fighting, it is unlikely that section would apply to the situation giving rise in this appeal, nor to the wide range of cases which arise in like fashion. The definition of prize fighting is an encounter or fight with fists or hands between two persons who have met for the purpose by previous arrangement made by or for them, but a boxing contest between amateur sportsmen shall be deemed not to be a prize fight. Since it is a condition of this offense that the fight be arranged previously, it is questionable whether the facts of this case would warrant a conviction on that basis. Although the trial judge found that the parties agreed to continue their fight outside the hotel, nonetheless it was essentially a spontaneous ad hoc event. The policy preference that people not be able to consent to intentionally inflicted harms is heard not only in the register of our common law. The criminal code also contains many examples of this propensity. As noted above, Section 14 of the code vitiates the legal effectiveness of a person's consent to having death inflicted on him under any circumstances. The same policy appears to underline Sections 105.1, 159, and 286 in respect of younger people in the context of sexual offenses, anal intercourse, and abduction, respectively. All this is to say that the notion of policy-based limits on the effectiveness of consent to some level of inflicting harms is not foreign. Parliament, as well as the courts, have been mindful of the need for such limits. Autonomy is not the only value which our law seeks to protect. Some may see limiting the freedom of an adult to consent to the applications of force in a fistfight as unduly paternalistic, a violation of individual self-rule. Yet while that view may commend itself to some, those persons cannot reasonably claim that the law does not know such limitations. All criminal law is, quote, paternalistic to some degree. Top-down guidance is inherent in any prohibitive rule. That the common law has developed a strong resistance to recognizing the validity of consent to intentional applications of force in fistfights and brawls is merely one instance of the criminal law's concern that Canadian citizens treat each other humanely and with respect. Finally, it must not be thought that by giving the green light to the common law and a red light to consent to fights, this court is thereby negating the role of consent in all situations or activities in which people willingly expose themselves to intentionally applied force. No such sweeping conclusion is entailed. The determination being made is much narrower in scope. F. Conclusion. How and to what extent is consent limited? The law's willingness to vitiate consent on policy grounds is significantly limited. Common law cases restrict the extent to which consent may be nullified, as do the relevant policy considerations. The unique situation under examination in this case, a weaponless fistfight between two adults, provides another important boundary. The limitation demanded by Section 265 as it applies to the circumstances of this appeal is one which vitiates consent between adults intentionally to apply force causing serious hurt or non-trivial bodily harm to each other in the course of a fistfight or brawl. Bracket. This test entails that a minor's apparent consent to an adult's intentional application of force in a fight would also be negated. End bracket. This is the extent of the limit which the common law requires in the factual circumstances of this appeal. It may be that further limitations will be found to apply in other circumstances, but such limits, if any, are better developed on a case-by-case basis, so that the unique features of the situation may exert a rational influence on the extent of the limit and on the justification for it. Stated this way, the policy of the common law will not affect the validity or effectiveness of freely given consent to participate in rough sporting activities, so long as the intentional application of force to which one consents are within the customary norms and rules of the game. Unlike fistfights, sporting activities and games usually have a significant social value. They are worthwhile. In this regard, the holding of the Saskatchewan Court of Appeal in the Queen and Say is apposite. The court's majority determined that some forms of intentionally applied force will clearly fall within the scope of the rules of the game, and will therefore readily ground a finding of implied consent, to which effect should be given. On the other hand, very violent forms of force, which clearly extend beyond the ordinary norms of conduct, will not be recognized as legitimate conduct to which one can validly consent. There's nothing in the preceding formulation which would prevent a person from consenting to medical treatment or appropriate surgical interventions. Nor, for example, would it necessarily nullify consent between stuntmen who agree in advance to perform risky, sparring, or daredevil activities in the creation of a socially valuable cultural product. A charge of assault would be barred if the Crown failed to prove absence of consent in these situations, insofar as the activities have a positive social value and the intent of the actors is to produce a social benefit for the good of the people involved, and often for a wider group of people as well. This is a far cry from the situation presented in this appeal, where Jobidon's sole objective was to strike the deceased as hard as he physically could until his opponent either gave up or retreated. Fist fights are worlds apart from these other forms of conduct. Finally, the preceding formulation avoids nullification of consent to intentional applications of force which cause only minor hurt or trivial bodily harm. The bodily harm contemplated by the test is essentially equivalent to that contemplated by the definition found in section 267 sub 2 of the Code, dealing with the offense of assault causing bodily harm. The section defines bodily harm as, quote, any hurt or injury to the complainant that interferes with the health or comfort of the complainant and is more than merely transient or trifling in nature, end quote. On this definition, combined with the fact that the test is restricted to cases involving adults, the phenomenon of the, quote, ordinary, end quote, schoolyard scuffle, where boys or girls immaturely seek to resolve differences with their hands, will not come within the scope of the limitation. That has never been the policy of the law, and I do not intend to disrupt the status quo. However, I would leave open the question as to whether boys or girls under the age of 18 who truly intend to harm one another, and ultimately cause more than trivial bodily harm, would be afforded the protection of a defense of consent, bracket, as was the accused in The Queen and Baron, in which a boy was charged with manslaughter via assault for pushing another boy down a flight of stairs, thereby causing the boy's death. The trial judge held that the deceased boy had impliedly consented to roughhousing on the stairs as they descended, end bracket. The appropriate result would undoubtedly depend on the peculiar circumstances of each case. It is now possible to move away from the issue of consent, but before summarizing the results of this appeal, it may be instructive briefly to address the possibility that the criminal negligence could serve as an alternative unlawful act on which the charge of manslaughter could be grounded. 4. Alternative grounds for conviction of manslaughter. A. Comparing assault and criminal negligence. Since the trial judge found that the appellant was not criminally negligent, the point was not addressed in the court below, and the appellant has not raised the issue of criminal negligence on appeal. It is not strictly necessary to analyze criminal negligence in this appeal. Nevertheless, it may be instructive to do so to provide more comprehensive understanding of the offense of assault, and to gain an adequate appreciation of the comparative operations of assault and criminal negligence. In The Queen and Carrier, Chief Justice Laycroft of the Alberta Court of Appeal suggested that in some fistfights or street fight cases, even if weapons are involved, criminal negligence causing death or bodily injury respectively under sections 203 or 204 may be the more appropriate charges, since criminal negligence is behavior which shows, quote, wanton or reckless disregard for the safety of other persons, end quote. In the opinion of Chief Justice Laycroft, A charge under those sections would focus on what he called the, quote, real issue in such cases, not whether there was consent, but whether the person who applied the force knew of the likelihood of risk to the life or safety of another person and proceeded with this action regardless of that risk. While that reasoning might commend itself in obviating the sometimes unavoidable difficult task of assessing whether consent was given, and of determining precisely what was consented to, the form of activity and the sorts of consequences, on balance, I am of the view that in the context now before the court, in the fistfight or street fight situation, those tasks will remain largely unavoidable. The prototypical fistfight constitutes a situation in which the concept and term, quote, assault, end quote, fit quite naturally. Criminal negligence is less well tailored to the situation. In a fistfight, two people line themselves up. They face one another and begin striking. There is typically an obvious intention to apply force to the other person. There is a consciousness that if one lands a hard blow to the other person, he or she will suffer some degree of pain or discomfort, at the very least. This conscious regard for some level of harmful consequence to the physical integrity of another person distinguishes assault from criminal negligence, where there is actually a disregard for the likely impact of one's conduct to the other's physical safety. With assault, there is a turning of the mind toward the complainant. With criminal negligence, there is a sense of turning of the mind away from the complainant. It may be that the foregoing reasoning has little merit in the context of injury caused by athletes in a rough sporting activity. For instance, it is easy to imagine a hockey player causing great harm to an opposing player by checking him hard, but in a way that would still be legitimately within the rules, save that in the quickness of the game he negligently failed to lower his stick just before making the check, thereby injuring the other through carelessness. Once again, however, I think it is best that these sorts of presumptions be developed gradually over time, in cases where the facts are more naturally allow for it. B. Other, quote, unlawful acts, end quote, which might ground a conviction for manslaughter. The Crown argued that if assault is barred by consent, Jobidon should be convicted of manslaughter on the alternative basis that he performed the unlawful act of causing a public disturbance. However, as this issue is not directly raised on appeal, it will not be addressed. Part 3. Disposition. I would uphold the decision of the Court of Appeal. The appeal is dismissed.
Legal Listening is founded by Zach Battiston and Carly Lyons. Hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radamile. Audio engineering by Anthony Radamile. Graphic design by Julie Lundy at julielundyart.com. Music by Matt Radamile at radandkel.com. We're always open to ideas, suggestions, and of course guest readers. Check us out at Legal Listening on Twitter and at legallistening.com. We'll talk to you next time.